for a change and welcome speech in the usually it is not me, sir. Usually I have my CLE committee, but unfortunately Aditya has a personal difficulty. That is it. That's why I'm here. And welcome speech. I don't think anyone needs a welcome speech, introduction speak about Arun sir. I have been practicing in High Court for the last 27 years, and the first person when I just joined the High Court, I've seen some smiley faces. The faces where always the smile was there, though they may be arguing the way they want, but still the smile never faded from their face. First one, sir, senior counsel, the late T.R. Ramapilla sir. Thereafter, T.R. Ramendran sir. Then V.J. Arun sir. Now, when they came to the bench, that is T.R. Ramendran sir as well as Arun sir, no matter what the lawyers used to do, there used to be heated arguments, there used to be a fight, especially when it is P.C. Shashidharan sir in the opposite, then it is definitely, it goes without words that there used to be a fight, tug of war between the applicant side and the respondent side. Despite all these things, we have never seen him lose a temper ever, always smiling. Be it the juniors who is arguing, be it the senior, there was always equal treatment from his bench. And we missed it very badly now, very badly. It's a fact. Sir, retirement samayattum yangal idu we will be missing that smile. Today, he is with us, all smiling again and ready to take us a class on recruitment. Sir, I welcome you. Welcome, sir, on behalf of myself as well as my committee, as well as the advocates present here. I also welcome our beloved members. I'm not taking long. Short welcome, sir. We all know our HOD, Sunil Thomas, sir, Judicial Member, Haripal, sir, and of course, our Administrative Member, Judge Mohan, sir. We welcome all of you to the session, and I assure you one more thing. As I said, you'll all enjoy that smiling class today.
Good evening, respected brothers, Justice Sunil Thomas and Justice Haripal, Administrative Member Mr. Brij Mohan, my friends at the bar. When Rekha, Shamina and Aditya asked me to come and take a class, I was under the impression that I'll be addressing a young lot of lawyers. I am a bit perturbed today for the reason that persons with high erudition, of which I know very well having been with them in the High Court, are also present. I've also got a lot of positive feedbacks about the administrative members here and the tremendous work they have done in disposing the huge number of cases of which there was a backlog, which is not there, which has come down substantially. And I also find the presence of stalwarts like Mr. TCG Swami, who in fact I've learned a lot from all of them. 29 years at the bar, 7 years sitting on the bench, of which for some duration I was lucky enough to be part of a service bench headed by Justice C.T. Ravikumar and a bench headed by Justice Vinod Chandran. Now, yet another factor which gives me a slight perturbation is that I'm not a good teacher. A good teacher is someone like Justice Sunil Thomas, who even while he was practicing had been teaching at the law college. Then even now, almost every week or every month, is taking classes to judicial officers at the Kerala Judicial Academy. So I'll try to pass on the little knowledge I've gathered as a lawyer and as a judge, confining to the basic aspects of service jurisprudence, particularly recruitment. Since I have a lot of time at my hands, I thought for a change, I'll do some research on the the service law as to how the service law developed in India. So contrary to what I have in my mind, probably many of you have in your mind, the service law in India did not start with the British. In fact, way back in during 322 and 185 BC itself, the Mauryan Empire had developed a sophisticated hierarchical system for selecting and promoting officials, performance evaluation, codes of conduct, loyalty requirements, and specialized rules. Much later, the Mughals also had a system of civil servants which they called the Mansabdari. Then the modern civil services started with the advent of the East India Company. More particularly when the East India Company moved on from trade and commerce to administration. So the roles of persons who were actually managing the commerce got coupled with administration also. And the term civil servant was coined then. And you'll find it in the old records, I'm told, way back in the year 1765. Now, as you all know, after the revolt of 1857, the British took over. And from there was a rapid change in the civil service system. It was Lord Cornwallis who, for the first time, said the civil servants shall not accept gifts. There shall not be any bribe. But with all the progress, the senior positions, which they call the covenanted posts, went to Europeans and Britishers alone. And there was no recruitment, it was based on patronage. The civil services exams was later on opened up for Indians also. But what the Britishers did was, the exam was held in England. And the time limit for native citizens, as they called us, and the Britishers were set differently. And with all those obstacles, can anyone tell me who the first? No, with all with all those obstacles, it was Satyendranath Tagore who could clear the ICS exam. Satyendranath Tagore, you should all know, correct, the older brother of Rabindranath Tagore, the great poet and Nobel laureate. That was way back in 1863. There was much progress under the British rule after that with regard to the system. The provincial service committee, public service, an authority like the Public Service Commission was constituted. The provincial service commissions came into effect. Even with all that, the Britishers had an edge when it came to civil services. The change came about and by the time the ICS, the Indian Civil Services, had been constituted, the change came about at the time of independence, and when the ICS became the Indian Administrative Service, and with the adoption of the Constitution and Article 309, the revolution took place, because 309 became the backbone as far as civil services in the country is concerned. Of course, we have 312 with respect to the Indian Administrative Services, but for today I'll confine to Article 309. So I'll start by reading the article itself. It goes like this. The caption being recruitment and conditions of service of persons serving the union or a state. Subject to the provisions of this Constitution, acts of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of any state, provided that it shall be competent for the President or such person as he may direct in the case of services and posts in connection with the affairs of the Union, and for the Governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and conditions of service of persons appointed to such services and posts until provision in that behalf is made by or under an act of the appropriate legislature under this article, and any rules so made shall have effect subject to the provisions of any such act. So, apparent from the plain words of Article 329, it is subject to the rest of the Constitution, including the fundamental rights under Part 3. Therefore, any recruitment rules, any procedure for recruitment, any appointment, it's all subservient to the fundamental rights under Part 3. And any violation, any derogation of the rights guaranteed will invite interference. Now, the substantive part of Article 309 indicates that it is for the appropriate legislature, which is the Parliament in the case of officials of the Union, and the state legislatures in the case of state government employees, to enact laws for regulating the service conditions of government servants. The proviso, however, confers power on the President or the Governor to frame interim rules under a provision in that behalf is made by or under an act of the appropriate legislature. This has led to a lot of issues as regards the interplay between the power conferred under the substantive provision, the proviso, and the power to pass executive orders in the absence of rules formulated in exercise of the powers of the proviso. And a question that also arises as to whether, in the absence of rules, as contemplated under Article 309, whether appointments can be effected to a post. Now, that is answered by the Supreme Court in Swarnalata versus Union of India, the citation being 1979, 3 SCC 953. Holding that it is not obligatory under the proviso to Article 309 to make rules of recruitment, etc., before a service can be constituted or a post created or filled. This is so because the state government has got the executive powers in all matters in respect of which the legislature of the state has power to make laws. Now, moreover, there is nothing in Article 309 which abridges the power of the executive to act under Article 162 of the Constitution. Now, at the same time, the rules framed in exercise of the proviso under Article 309 cannot be overridden or substituted by executive orders. At best, the executive orders can only fill up the gap in the statutory rules, if any. Now, one of the main decisions on the point is Ajay Kumar Das versus State of Orissa, that is 2011 11 SCC 136. The relevant portion being, whatever be the efficacy of the executive orders or circulars or instructions, statutory rules cannot be altered or amended by such executive orders or circulars or instructions, nor can they replace the statutory rules. The rules made under Article 309 of the Constitution cannot be tinkered by the administrative instructions or circulars. Now, from what we have discussed or what I have stated, the prescriptions under Article 309, which provides the constitutional backbone for the entire system that determines how posts in public service are filled, can be summarized as follows. One is the power to regulate the recruitment and conditions of service by the union and the state legislatures are subject to the other provisions of the Constitution. While recruitment and conditions of service are to be regulated by the legislature, the executive's law-making power can be resorted to and will remain operative till the legislature has made such laws. Even though gaps in the statutory rules can be filled through executive orders, such orders can only supplement and never supplant the rules. Now, while discussing on the aspect of recruitment, we should have a clear understanding as to what recruitment means. I say this because many a time we find that the terms recruitment and appointment are used interchangeably. Now there is a marked difference between the two terms. Even in some of the judgments, we come across the usage of the terms recruitment and appointment in an interchangeable manner. Now, recruitment connotes and signifies enlistment, acceptance, selection, or approval for appointment. I'll repeat. Recruitment connotes and signifies enlistment, acceptance, selection, or approval for appointment. On the other hand, the term appointment means the actual act of posting a person to a particular post. So there is a marked difference. So it is only the enlistment, selection, etc. is recruitment, whereas the actual posting is appointment. Through the process of recruitment, a candidate becomes eligible for appointment. And I should also say, though every appointment has to be preceded by a process of recruitment, recruitment or enlistment need not necessarily culminate in appointment. Now the question had arisen as to whether the person who has been included in the select list who has gone through the process of selection, and ultimately the employer, the organization says that we are not appointing you, can he approach the Constitutional Court and seek a mandamus directing that he be appointed since he has cleared the selection process and come out successful. And that one of the local, or rather the locus classicus on the point is Shankarshan Dash versus Union of India, that is AER 1991 Supreme Court 1612. Categorically holding that mere inclusion of candidates' name in the select list does not confer any right to be selected, even if some of the vacancies remain unfilled. The candidate concerned cannot contend that by refusing appointment he has been subjected to hostile discrimination. But however, in the same judgment, the Supreme Court struck a note of caution by holding that the state does not have any license or unbridled power to act in an arbitrary manner, and the decision not to fill up the vacancy has to be taken bona fide and for appropriate reasons. Now, when we delve deeper into the aspect of recruitment, the next question that arises is what is the fundamental requirement for initiating the process of recruitment? The answer is the existence of vacant posts or posts and ascertainment of vacancies. This is so because there is no valid appointment, there can be no valid appointment except to a vacant post. Now, one of the cases on the point is the Himachal Pradesh Road Transport Corporation versus Dinesh Kumar, that is 1996, 4 SCC 560. The Himachal Pradesh government had this transport corporation had this practice of appointing the kith and kin of deceased employees, more likely the compassionate appointment scheme. Now, there was a huge backlog in the corporation for kith and kin appointment, particularly for the reason that the transport corporation was operating on treacherous roads and the number of deaths were very high. Now, two of the candidates approached the court saying that we have been waiting long in the queue for appointment, and therefore there should be a direction to they in fact approached the tribunal, Administrative Tribunal there, and there should be direction to the authorities to appoint us in a time-bound manner. The tribunal answered positively and directed appointment of those persons. Now, going by the term, there was no vacancy at that point of time to accommodate or to appoint them. And therefore, the Transport Corporation approached the Supreme Court, and the direction issued by the tribunal, even to appoint these persons even in the absence of vacant posts, as per the was set at naught. The Apex Court held that in the absence of vacancies, it is not open for any public authority to appoint any person to any post. Now, having said that, vacant posts, it is also pertinent to note that there can be the process of recruitment can be initiated with respect to anticipated vacancies as well. Now, but not with respect to future vacancies. There's a marked distinction when it comes to anticipated vacancies and future vacancies. Vacant posts are ascertained at the time of initiation of the process itself, and anticipated posts are those posts which will fall vacant by reason of retirement, promotion, etc. And to that extent is therefore an ascertained set of vacancies. But when it comes to future vacancies, it depends on a lot of contingencies which cannot be foreseen at the time when the recruitment process is initiated. Therefore, there's a clear interdiction as far as filling up of future vacancies by initiating a recruitment process in advance is concerned. Now, one of the reasons for such interdiction is the long duration for which taken up to fill up the future vacancies, and during that interregnum, there will be many more qualified persons coming out whose chance of participating in the process of selection is defeated by not in this process. Now, on the vacancies and the posts, the final conclusion is the process of recruitment can commence only if vacant posts are available. Anticipated vacancies can also be included in the process of recruitment, but there cannot be any recruitment as regards future vacancies. Now, the next step in the process of recruitment is identification of the sources from which the recruitment is to be made and the mode of recruitment. Now, the sources of recruitment can broadly be divided into internal and external sources. The internal source being the already existing staff in that organization, whereas the external source will be the open market consisting of job aspirants. Now, the external candidates will have to participate in a process of selection to be eligible for appointment, whereas the internal candidates are normally promoted and appointed based on their seniority and efficiency. Now, there may be a question as to whether the internal candidates are prevented from participating in the recruitment process along with other external candidates. Now, there cannot be a complete ban on such participation because that will militate against the equality principle under Article 14 and the equal opportunity under Article 16. The best that an employer can do is to bring in a requirement of seeking prior permission before an internal candidate opts to participate in a recruitment process as an external candidate. And in fact, in many organizations, a certain quota is fixed and set apart for internal candidates to participate and get promotion. Even in the judicial service, we have such provisions. Now, another mode of recruitment from external sources is deputation, which is usually effected to higher posts. The candidate seeking appointment by deputation will also have to undergo the process of selection by like other regular candidates. The only difference being that regular candidates are appointed and will continue in service till retirement, but a person appointed on deputation is for a fixed tenure. So now, as far as internal source for recruitment are concerned, as I said earlier, it goes by appointment by promotion, transfer, and absorption. In SS Moke versus Union of India, 1981, 3 SEC 271, the Supreme Court has held to be within the domain of the government to decide, as a matter of policy, the sources from which the personnel required for manning the services are to be drawn. Now, the very fact that recruitment can be from different sources gives rise to the problem of ratio to be fixed between the different sources. It is through a plethora of catena of decisions, it has now been settled that when recruitment to certain posts are made from different sources, what ratio would be adequate and equitable would depend on the circumstances of each case and the requirements and needs of the post. Normally, or the courts cannot intervene in the fixation of ratio by an organization or the government unless the ratio is so unreasonable as to amount to discrimination. And it is not for the court to suggest a different ratio from what has been fixed. Now, there is another form of recruitment which is of recent origin, which we call the campus recruitment. Now, in the public services, there cannot be any campus recruitment because that will also go against the equality principle. Now, I had one case before me where a public sector bank opted to make appointments from among persons who had completed their LLM course from national law schools. Now that by that process, the others who had come out of other law schools were kept aside, and it did not reach its conclusion because midway the bank decided to withdraw the notification. So, as far as public services are concerned, there cannot be any campus recruitment at the moment. We don't know what the government will decide in future, because campus recruitment gives the organization or the employer a chance to pick up candidates, prospective candidates from selected colleges, and thereby denying opportunity to others from different colleges. Now, now the modes, the ratio, and the sources are fixed. Then the process of selection has to start. Now, that process starts with the advertisement of the notification by giving wide publicity so that every eligible person gets an opportunity to participate in that process. The importance of publicity and transparency by virtue of the advertisement has been elucidated in K. Shegar versus Indira Mata, that is 2002 3 SEC 586. Now, the date of advertisement is the absolute discretion of the employer. Now, a candidate cannot, or a prospective candidate cannot challenge the advertisement saying that the date should be sometime later, because by that time I will also achieve the eligibility or the qualification which is required to participate in the process. Now, it is, I did not, because you are doing it on a daily basis, I did not say that that the advertisement, the notification should be in terms of the recruitment rules, and any deviation would invite intervention by the court. There can also be a challenge if the selection is done contrary to the stipulations in the notification. Now, K. Manjushree versus State of Andhra Pradesh, 2008, 3 SEC 512 sets out a classic example. There, the full bench of the Andhra Pradesh High Court fixed a different criteria than what was prescribed as by upping or increasing the marks for the member was the interview in the selection process, and that was challenged. Now, affirming the challenge, the apex court held the full court could not have introduced a new requirement of minimum marks in interviews, which had the effect of eliminating candidates who would otherwise be eligible and suitable for selection. This was selection to the post of district judges in Andhra Pradesh. And having said that, I should also point out there are a lot of cases which arise from in relation to selection to judicial posts across the country. We have had a lot of cases in Kerala also. Now, I just thought about that, and I thought the two reasons came to my mind. One is the prospective candidates are lawyers, and they are quite capable of picking holes in the process. They have the expertise, the wherewithal, and therefore it is the rules, the procedure, everything is scrutinized minutely, and any deviation will start a litigation, process of litigation. The second is, to a certain extent, we should blame the High Court itself. The High Court sometimes seems to be under the impression that the king can do no wrong, and and therefore when full court meetings are held, a decision is taken, and let us go on like this, in spite of persons with expertise like Justice Sunil Thomas pointing out there are mistakes, because we have come across cases where such discussions were held, and by the majority it is decided, subjected to challenge. And when it comes to the Supreme Court also, in the case of judicial officers, they find ways and means to somehow accommodate the persons who have already been selected. Of course, there have been cases where after selection and after joining as district judges, there has been interference and they had to go out of service. Some of them later came back also. One of the other factors, or rather two of the other factors to be clearly set out in the notification inviting applications for selection is the eligibility and qualification required for selection. It is now settled law that is the employer is the best is best suited to decide as to the eligibility and qualification of the candidates. And it is not for the court to say that this would have been a better eligibility or you should have prescribed this sort of qualification. But then the eligibility should have a clear and rational nexus to the environment sought to be affected. Now, if you want a Hindi teacher to be appointed, you can't mandate Bharatanatyam as a qualification. And there can be a challenge against the prescription of eligibility on the ground that it violates the fundamental rights under Article 16 also. One such case was with respect to the appointment of statistical assistant by the Andaman and Nicobar administration. The decision is Union of India versus Sanjay Pant, year 1993, Supreme Court 1365. The candidate, the petitioner had undergone the process of selection, and at the time of interview, because it was there, it was a prescription in the notification that the candidates should be local residents of Andaman and Nicobar Islands. At the time of interview, he failed to produce the local candidate certificate, and therefore he was not selected. He challenged it before the Supreme Court, saying that it violates his rights guaranteed under Article 16(2). The Supreme Court found that under 16(3), it is possible for the government to prescribe such qualification. But as far as that case is concerned, there was no such prescription by the government by way of any rule, order, or notification, and therefore the denial of selection was found to be illegal. Now, one other major question that had come up before the courts of law time and again was as regards the prescription of the cutoff date for eligibility. There have been instances where the notification, the rules does not prescribe, and the notification, no mention is made regarding the cutoff date for eligibility. And therefore, the question arose as to what should be taken as the cutoff date for eligibility. Many persons would acquire the eligibility during the process of selection, and demand that they should also be considered for selection since they have the requisite qualification or eligibility at the time when by the time the process is completed. Now that question was set at rest by the Supreme Court in Shankar Mandal versus State of Bihar, 2003, 9 SEC 518. Therein the Supreme Court carved out the following principles for prescription of cutoff date for eligibility. The first is the cutoff date should be the date appointed by the recruitment rules, provided it is there. And in the absence of the date so appointed in the recruitment rules, then it will be the date appointed in the advertisement. And if there is no such date in the advertisement, then it will be the last date of application. So candidates who have the requisite eligibility as on the last date of application can be considered selected and considered for appointment to public services. Now, these are the broad aspects on which regarding the process of recruitment and the mandatory factors to be complied with by the government or the employer while during the process of recruitment. So the normal rule is the courts or rather would prefer not to interfere in a process of recruitment, especially when it comes to public services, keeping various factors in mind. The large number of persons who are participating, the requirement of filling up the posts, minor deviations that may result in the entire process being restarted again, which will definitely be a time-consuming process. But there can be interference when the selection process, or rather there should be interference when the selection process is fundamentally flawed and cannot be corrected by partial remedies. Some of the examples are cases where recruitment is conducted without advertisement, vacancies are filled without proper public notification, eligible candidates are denied opportunity to apply, violation of recruitment rules, mistake or rather illegality in prescribing the eligibility and qualification, ignoring the prescribed qualifications, age, criteria, etc. during the process of selection. Now, the key judicial principle that emanates from the whole discussion is that when illegality affects the fairness, transparency, or integrity of the entire selection process, making it impossible to identify genuine merit through the existing recruitment exercise, the constitutional courts should interfere and direct fresh recruitment to be conducted. This will ensure compliance with Articles 14 and 16 and protect equal opportunity and restore public confidence in the recruitment process. We are at a stage where unfortunately public confidence is at its lowest as far as certain recruitment processes are concerned. Now, sitting in the High Court, when challenges are made against the these the admissions conducted by the National Testing Agency, the selection through the Public Service Commission. One would, as Rekha said, and stoutly opposed by PC Advocate PC Shashidharan, one would be inclined to think that the process is foolproof and there should not be any interference. But that much confidence cannot be there at this point of time, because we find that many times it is flawed, either in the preparation of the question papers, the manner in which the answers are selected, or some answers are omitted, the flaws in the electronic system through which the marks are decided. And therefore, I think there will be all the more challenges and all the more interference if this process, or the flawed process, is to continue. It is high time that all come together and restore the trust in the system of selection, because of the huge number of the unemployed persons who are waiting for employment, and their only means to secure public employment and public service is through these modes of selection. Finally, as far as challenges are concerned, the court will not normally entertain a belated challenge. One case on the point is Madanla versus State of Jammu and Kashmir, 1995, 3 SEC 486. Be that as it may, the Supreme Court has also held that when the selection is in violation of the recruitment rules, the same can be challenged even after participation. That is Jagbir Singh Sodhi versus State of Jammu and Kashmir, 2023-17 SCC 147. So these are the broad aspects with which I've come prepared. I know that I've not covered a lot of other aspects, but as I said at the beginning, I'm not a great teacher, and not being a great teacher, I think it will be wise to wind up when the going is good. So far, I think from the reactions, so far I've held up, and if I go further, I may fail. So thank you very much for a patient, and let this, and I should appreciate the efforts being taken for this this continuing legal education. For me also, because after retirement in January, my learning had come to a sort of it was grinding, it was coming to a sort of grinding halt. And this call to come and make a presentation had given me an opportunity to start up again. So on that note, thank you for giving this opportunity. Thank you very much.
Thank you, sir. Now I invite our Honorable HOD, Justice Thomas sir, to give a memento to on behalf of the associated justice.
Thank you so much, brother.
Sure, thank you.
The simple but quintessential duty of expressing vote of thanks falls upon me in the absence of the committee of the CL. Now, every time a session ends, it's usually done in a hurry-burry, but fact remains that without expressing gratitude to each and every member who contributed to the conduct of a CLE, this function would not go ahead. I thank Honorable Justice, Retired Justice V.G. Arun sir for having graced us on this occasion, preparing the topic and presenting it to us in such a way that it might be useful for each of us the next time we argue these matters before the benches.
When put in practice.
When put in practice, yes. I move on to the honorable members of the CAT. I thank each and everyone, Justice Sun Thomas sir, Haripal sir, and Brajmohan sir. It was I expressed my humility. In fact, it was the last moment that we wanted this courtroom to be arranged for this session, and Sun Thomas sir readily granted us that permission. I thank you, sir, and I thank Haripal sir and Brajesh sir for this opportunity. Thank you, sir. Now, I know the number of participants for this occasion is very few, but I also appreciate that the Onam board has not let each of us not exploit this opportunity. So I thank each and every participant for being here on this occasion despite the Onam board. I thank you all. I also express my thanks to the staff of the CAT who made arrangements in this court hall. I thank them all. Thank you.
Why do we exploit you to